Okay, good morning, ladies and gentlemen. My name is Kelly Thompson. I'm a justice on the Supreme Court. We have four levels of court system. I know all of you most are going to know most things I say, but I'm going to say them. Anyway, we have the district court, and that's where the rubber meets the road. That's where most of the public sees our court system, with speeding tickets and misdemeanors, arraignments, small claims, those kind of small issues. We have family court, which is that's up at the circuit court level, the next level up, and the family court is exclusively in domestic court. Domestic court, family court is a real hard job, because the emotions that come forth when people are getting a divorce or having a custody issue or a dependency issue or a guardianship issue, all of those things come to the family court, and just like osmosis, the emotions of the clients permeate into the attorneys, and they get upset. It's a very stressful court because of the stress, and you all are the doorstep to the justice system. A lot of people call you and talk to you, your clients, your attorney's clients, and just remember, they're all in stress. I know when I go in the hospital for surgery, I am at loss at how the hospital system works, and it's scary to me to be there in this strange place under the control of other people. Same thing when people come into the justice system. They're scared. They're afraid. So always remember to do God's work and hold their hands and give them directions and give them peace of mind. And I believe in karma, and you'll get it back. After the circuit court level, and that's where you have your felony trials, your major litigation in civil cases, and summary judgments in those cases. If you don't win that case, you have a right to appeal. In Kentucky, everyone has one right to appeal. If you're in district court, you have a right to appeal to circuit court if you lose in district court. If you're in circuit court, you have a right to appeal to the Court of Appeals, except when you've received a sentence of 20 years or more, or you're in a workman's compensation case. Both of those have exceptions which allow them to directly appeal and get into the Supreme Court, where I live. Now, the Supreme Court, we have the most marvelous justice system. There's 7 justices. We have to have 7 geographic districts. We divide the state into 7ths. And so all 7 of us come from a different place. And if we didn't do that, Louisville would have every justice on the court because of its size. But this guarantees that the justices come from all parts of the state, and we come from all various legal backgrounds. I was a trial lawyer. I tried over 500 jury trials in circuit court and federal court, and loved talking to juries, just loved it. I think I'm the only trial lawyer on the court. There's 3 that were judges, all come from different areas, and they all come from different backgrounds. And so we go out and we read the briefs, and we hear an oral argument, and then we go back in this conference room, and the 7 of us start chewing on the issues, and it's a debate. It's an academic debate on what's the proper thing for these people, for the future, because when we write a decision, it's going to hold up and guide other cases that are similar in the future. The judges and the trial lawyers in the future will be reading that opinion and saying, this is how the law goes. So we argue and we debate, and boy, we have 4 to 3 decisions, 50% of the time. It's 4 to 3. And the votes on the 4 to 3 change. Like with the Supreme Court of the United States, they go, well, here's these 6 Republicans, or here are these 3 Democrats. No, we're not Democrats. We're not Republicans. We don't think about money. We don't think about power. We think about what's the precedent, what the law is, and how it applies to this situation. And It's just a marvelous system. It really is. Now, when I came back to Bowling Green, after being a clerk at the highest court and practicing, working for the highway department, representing them for 40 jury trials, I came back to Bowling Green and I got some offers, but I was arrogant and I wanted to start my own practice. So I was going to have the biggest law firm in town. And I started out with 8 lawyers and 5 secretaries. And it didn't work because it's personnel. Dealing with personnel is the worst problem there is. I believe in the philosophy of you get a good bed and sleep good 8 hours a night, have a good mate and have 8 hours of domestic bliss, and walk into your office with 8 hours of happiness. Don't have anything that's negative in any of those 3 places, and you've pretty well got life taken care of. And I would walk in and there would be this infighting going on, mostly between young lawyers who were all just as ambitious as me. And so I learned all those lawyers, I put them up somewhere else, and I had 4 paralegals and me, because I realized that the license to practice law was the only license I needed to walk into the courthouse. These people back at my office doing the work, the paralegals, they didn't have to have a license. So I had one paralegal who did only divorces. And people would come in and I'd listen to them and I'd figure out their case, take them into her. Next thing I know, I'm going to court for a hearing or doing this. She's just telling me what to do, where to be. And another one did automobile accident litigation and specialized in it and became very good at it. Another one did bankruptcies. And so I got all my work done with just me and my license, because my license let me go over and talk to the judge, and they would prepare my cases so well. And as a young lawyer, I said, I want you to dress up and look good for this jury. Wear the best thing you have. Well, these guys didn't ever go wear a suit, but they did have a tux from their brother's wedding. So the guy comes in his tuxedo. Well, he doesn't look too good. I mean, he looks great, but he's uncomfortable as he can be because he's not used to wearing a tux. You know, he's squirming and doing this. So I thought, well, that's not going to work. So I said, dress in the best outfit you have. Well, this black man comes in, and he is a disco guy, and he's wearing a pink polyester outfit that buttons at the navel with his chest hair sticking out, and he's got on these green polyester tight stretch pants, and he comes in and he feels so good. And jury finds him not guilty. He's so comfortable in his clothes. But I thought, this ain't gonna work next time. So I started telling him, dress like you're going over to your mother's to eat lunch on Sunday. And that kind of worked. Now with the prisoners, they had these tattoos, jail tattoos. Well, I gained about 50 pounds, so I had a line of shirts in my closet that was every size you could imagine, because my neck size kept going up. And as my nephew said when he went in there, he said, this looks like looking at rings in a tree, the different shirts. But I would take one of those old shirts that no longer fit me down to the jail the night before the trial, and they would put on a white shirt and button both arms and leave the collar open. It's amazing how good they looked compared to all those tats and the prison tats all over you. And all of a sudden you got on a white shirt, you look really good. Another thing I liked with paralegals was I found that communicating with a witness, if you over-prepare a witness, it's terrible on the witness stand. I over-prepared a witness one time in a car accident case, and I put her on the witness stand, and in my office I thought she would be the best witness I had. And she got on the witness stand and she shrunk back and sat way back and slid under the thing like this, and she was chewing gum. And I said, well, tell me what your husband could do before the accident that he can't do now. Well, I have to do the mowing now. And I said, well, what else? And she said, I forgot what you told me to tell the jury. So it was a lot easier for me to let a paralegal interview the witness and highlight the best stuff that the paralegal thought came out of that witness's mouth. I wouldn't talk to the witness at all. And they'd say, I want to talk to you. I said, I'm not going to talk to you till you get on the witness stand. So they get on the witness stand, and you go, hello, ma'am. What's your name? What's your age? I asked one woman, I said, how old are you? And she said, I've lied about my age so much, I don't remember. She was about 80, you know. And so anyway, you start out comfortable, and you start out like you had a conversation with somebody that you meet drinking at the coffee shop. And it's so natural. And I'd go stand right over on the edge of the jury box, and that way the witness would look at me and they're looking at the jury. Now, if I'm cross-examining somebody, I would stand over to the far left of them and make them turn their head this way to the jury to talk to me, because you can see liars sideways a lot better than you can from the front. I'm serious about that. Their eyes start flicking down and you can see that flick when you're looking from the side. So whenever I had a witness that was deceptive, I would look at them from the side. There was a judge, McAnulty, a famous judge. He got to the Supreme Court. He was a black gentleman from Louisville. He started out as a district judge. Then he became a circuit judge. Then he got on the Court of Appeals. Then he got on the Supreme Court. But back when he was a circuit judge, he was in a trial, and the lawyer came up to him and said, Judge McAnulty, I want you to wake up juror number 33. Juror number 33 is asleep. McAnulty said, well, you wake him up. You put him asleep. McAnulty, like I say, was a black gentleman, and he lived in the west end of Louisville. It was mostly black. And when he ran, he would put posters up with his face on the poster on the west end, and on the east end, he had a green poster that said, elect Judge McAnulty without a picture. And they all thought they were voting for an Irishman. And he wasn't Irish. And this was a big joke, that he was using the Irish the perfect way to win an election. So when he died, he was told he had a terminal illness. He had 6 months to live. During that 6 months, he totally organized his funeral, deeded his property to his wife and his kids, and had his estate gone. No probate when he died. But anyway, one of his things was, I'd like all the judges that want to come to my funeral and wear their robes. So we had 150 judges wearing robes at this funeral. And we go in and take up a third of this big Catholic church in Louisville. And it's a beautiful service, and he's told who's going to speak and how long they can speak. He's orchestrated this entire service. So we're walking out. First, we walk out and form a gauntlet, and everybody that comes out has to shake our hands all the way down all these judges' hands. Anyway, we're walking out, and on the top of the music that comes from up at the top of the church, it was going, "Oh, Danny boy," and he was playing the Irish song when he wasn't Irish. I don't know how I got off on that. Anyway, paralegals are very, very important for our system, and it's hard to give you CLE because each one of you are kind of tied to the specialty of the practice of the lawyer that you work with. And so that covers a gamut of possibilities of what to talk to you about. The main thing I know about paralegals is that you don't get paid enough, and if you become indispensable to that attorney because you're psychic with him, he can talk to you after 5 years with being partners, you're partners. And after 5 years, he doesn't have to explain things. He just gives you 5-word instructions, and boom, out comes everything he wants because you've done it so many times. Now, you're indispensable to that lawyer. Ask for more money. Don't tell them I said that. Talking about cases when I was young. I started out, I got the public defender contract, so I was representing my own cases and them. It wasn't exclusive like it is now. And I had a guy, and he was from Scottsville, and he came over, and this is around 1976, and we had strip clubs in Bowling Green, and there was one down by the river. I can't remember, Uncle Sam's, I think they called it. Anyway, it was down by the river, and this guy goes to that strip club, and he's having a good time. Just an old boy from Scottsville, a farmer, about 20. And the stripper comes over and dances over next to him and handcuffs him with some toy handcuffs to his bar stool. And she dances off, and he can't get those handcuffs off. And what's the good old boy do? Pulls out his gun and shoots him off. Well, the bartender says, I got to call the police on this. You'd better get out of here. So he goes out the back door, and here he could hear the sirens already. So he takes off running, and he runs across the railroad tracks where the bridge is, the railroad bridge down by the river. He runs across those railroad tracks, and he goes behind that big tobacco warehouse that's on the left on that corner over there. Well, he's back behind that tobacco warehouse for about 15 minutes. And here comes a police officer around the other side of the tobacco warehouse, and he walks around, and that guy sees the police officer coming, and he takes off running, and he runs across Beach Bend Road, and there's no fence there then. He's running full speed, and he runs right off that cliff and lands down at the riverbank. I always saw the road runner when they got, anyway, he hits that riverbank down there and breaks his arm, breaks his leg, goes to the hospital, and he gets in court about 10 days later. He comes in with his crutches and everything, and the prosecutor looks at me and said, I think he's been punished enough. And we sent him home to Scottsville. I don't know where that fits for paralegals, but all right. Got any questions? Anybody? All right. Well, let's think about it. I didn't bring any notes, so that's where I should have. I got lots of stories to tell you that are kind of funny if I can remember any of them. Steve Wilson was the judge for many years here, and Steve and I were on Larry King Live. And we're flying up to Larry King, and Steve is nervous as he can be. And I'm going, Steve, don't worry, we're on Larry King Live. And Steve's going, I can't drink coffee, I can't do anything. Well, anyway, we get on there. The producer comes over and says, Mr. Wilson, you've got the only earbud that I can talk to, and I want you to give Mr. Thompson his instructions. So we get started, and the guy says to Steve Wilson, tell Mr. Thompson not to look all the time at Larry King, to look at the camera and Larry King. He turned around to me and said, he said for you to look at the camera the whole time. So I'm staring at the camera for the first 15 minutes or 5 minutes or however long it was till we took a break. And the producer came down and says, I told you to look at, I said, Steve. Anyway,
What Larry King Law for?
I had a woman who shot her doctor here in Bowling Green on Prozac. He gave her lots of Prozac for her workman's comp back injury. Nothing to do with her mind or anything. He loaded her up with Prozac. And one morning she woke up and she was going to a doctor's appointment at his office. And she carried a gun under her seat for protection because she was up in Ohio County. And she drove down Natcher Parkway. She went to the office. She went in. He comes in to the door, the doctor does, and says, well, hi, Rebecca, how are you doing? And she shoots him. And he said, I just walked in that door, and all of a sudden there was this red flash, and I was on the floor. I thought I had a heart attack. That's what he thought. And the bullet went in right here and came out back here and didn't hit any spinal cord or blood arteries or anything. It just went straight through his neck and just missed his spine. And anyway, she has the gun, and she is pulling the trigger, but it's jammed. And she's doing this to his face, and he said he looked up at that gun, and his adrenaline kicked in, and he hopped up off that floor like a kung fu guy and busted the door off the hinges, and they all went out front. I mean, that was great doctor, a great guy, and he was just an innocent victim, but she didn't remember any of it because she was so much on Prozac. The jury gave her 5 years, I think, maybe 10. I can't remember. Anyway, Larry King had us on there because of Prozac, and it was a lot of fun. Talking about Steve Wilson, Steve is such a prankster. My job is on this. In 1975, we voted on a judicial amendment that changed our world in Kentucky. It was enacted in 1976, and in that amendment, we codified that we are a third and separate branch of government. And we created the Supreme Court then. Before then, the highest court was the Court of Appeals. So we added another level to the court system. And so we've only had a few justices on the court. John Minton was the Chief Justice that I replaced. And before him, we had Judge Charles Reynolds. Mike Reynolds is his son at Reynolds Johnson, whatever they call themselves. And Mike and I were altar boys together in Catholic Church. But anyway, we're at Charles Reynolds' funeral. And it's a grand funeral. It's down at the St. Joseph's Church. And I've got, at that time, District Judge Joanne Coleman, Prosecutor Steve Wilson, Court Administrator Jim Gildersleeve, and me in the same pew. And we get to the Catholic, to the communion. And Jim turns around to Steve and says, Steve, you're a Catholic, I'm not. I'd like to walk through the Catholic line, the communion line. Is there a sign that you give to tell the priest that you don't want the communion? And Steve said, oh, yes, there is, Steve. Here's the sign. And that's not the sign. Anyway, so Gildersleeve goes up and goes through the line, and the priest has that communion, and here he is doing that. He comes back, Steve, why did you do that to me? And Joanne Coleman says, Steve, you're going to burn in hell for that. That's what a jokester he was. Now, for citations, and this is the stuff that you all are magnificent at, is dotting the I's, crossing the T's, putting out a finished product for your attorney with both of you working together that is you're proud of when it gets placed in front of a judge or even the opposing party. A good work document, good work result. Well, now that we're up here now that I'm up here at the Supreme Court, which is such a joy to me, we find that pleadings sometimes are really excellent, and sometimes they're not. And I don't believe in criticizing other lawyers, and I believe in deciding a case on the merits. Don't penalize the client for what the lawyer did. If a lawyer screws up, punish the lawyer, don't punish the client. But unfortunately, I don't win on that argument very often, and the clients get burned. I had two cases that I've tried to get our court to change on. One was called Barry Saturday. Barry Saturday was representing himself, and he was supposed to file his notice of appeal, and he had to file it, and the rule said by registered mail. Well, he went to the post office, spent $25, and sent it by certified mail. They threw him out of court, dismissed his case because he didn't send it by registered mail. I wrote an opinion begging him. This is such a minor violation. We also, with electronic filing, have had cases that people tried to file. We had one where the clerk had closed the file, closed the electronic file. You couldn't file anything in it because the clerk didn't understand that the case wasn't final until the time lapse for the notice of appeal. The clerk closed it the day the court made a judgment. This guy tried to file the appeal. There was a related juvenile appeal, so he filed it in that timely and said, I can't get into the other file. and I'm filing over here in a timely manner. Please put this in the other file. And the majority of my court threw that out, said that was dismissed for failure when it was the clerk's fault. So the bottom line is, don't put things off to the last day. That's what that comes down to. Go on and get your stuff done. Don't procrastinate. And make sure your lawyer doesn't procrastinate. Nag him until you get these deadlines. And the more you go up the ladder, the more strict they get with their compliance with the rules. So read the rules on everything you're doing on an appeal. I had a guy one time, and we had a judge named Judge Allender. Judge Allender had one arm. He lost it in a farming accident when he was about 14. And so he had one arm, played a good game of golf with one hand. And he was a rule guy, and he had a rule in his mind. If you have never been convicted of a felony, he's going to probate you the first time you're in felony court. If you've got a prior conviction, no probation. That was his rule, period. So I had a guy, he had a stolen car in his possession and pled and got a felony conviction. Well, lo and behold, 2 years later, he's got another stolen car in his possession, and he's in there. And so the Commonwealth attorney says, let's have a trial, and the trial, I'm going to offer him 4 years or he can go to trial. And I said, well, we'll go to trial, and I'll tell him he's guilty, and they'll give him 1 year. Because that's the beauty of our court system here. We have jury sentencing. So you get to have a trial on whether you're guilty or innocent, but then you get to have a trial on what the sentence ought to be. And if during the sentencing trial, if you got a nice looking guy, articulate, can talk, not a bunch of tats, or he's wearing my white shirt, the jury is going to feel for him, and you put his mother on, his family on, his friends on. They're going to feel for him, and they're going to give him the minimum sentence. You got a guy that you wouldn't want to bump into in a dark alley, you're going to give him the maximum sentence. You know, some guy that just scares you by looking at him when you're walking down the street, you don't put him on for a sentencing trial. So anyway, this guy had the stolen car. And I said, look, the judge is not going to probate you. You will not get probation. I got you 1 year, the minimum sentence. He said, okay, I'll take it. So he pleads guilty to the year. Well, in Kentucky, after you plead guilty, you don't get sentenced. You have to have a pre-sentence investigation to make a recommendation to the judge as to what the sentence ought to be. So we get there, and the judge has 3 weeks later, and the Judge Allender's looking down at him with his glasses on over his nose, and he says, I hereby sentence you to the custody of the sheriff, to take you to LaGrange, to be in the custody of the governor, and to serve your sentence. And the guy goes, but Judge, you got to probate me. And Judge Allender said, what? He says, because I found Jesus in the jail. I found Jesus, Judge. I found Jesus in the jail. And Judge Allender calmly looked over his glasses and said, well, here's what I'm going to do. I'm going to enter an order to release Jesus from the jail. And you're going to the penitentiary. Anyway, after you have entered your plea, you still can appeal, and you can reserve it in a criminal case. Somebody asked me a question. Who's got a volunteer question here? Come on.
Well,
nobody.
So there's 7 of you all, and so
come on up here next to me. Come on.
Well, I'm just wanting to.
Where's my microphone? Oh, right here.
Okay, I'll come over here. I just want to kind of get a general idea of how you all are set up. Like, there's 7 of you all. Where are you located? How often do you all meet?
Okay.
Like, what's the whole process?
The logistics.
Yeah.
What's your name?
Kim Yates.
Kim Yates.
I work at the U.S. District Court, one of the clerks over there.
Okay.
Just been there for a little over almost 2 years.
I used to date a girl named Kim Yates, but that was a long time. It's not you.
No, it was not.
Okay. All right. You can go back to your seat now, Kim. All right. On the Supreme Court, and there's a lot of unwritten rules when I got there, and I'm not sure they told me all of them correctly because I thought I might be getting played some. But anyway, we go to Frankfurt 1 week a month. When I worked at the Court of Appeals, which was the Supreme Court then, they would go to Frankfurt for 9 months a year and take off 3 months a year and go back home to their districts, to their houses, and campaign. They would have or get ready to run for their next office. But most of them had a house in Frankfurt and a house in their hometown where their residence was. But now, since then, it has evolved to where we work 1 week a month, but 3 months we don't go. And the week a month usually starts around the second Monday of the month. And we start out with the administrative docket. The first day on Monday, we start with administrative. Administrative is a boring thing, but you learn everything going on in the court system, security at courthouses, construction of courthouses, disciplinary problems, things that we can do to help the administration of justice. We have 7 justices. One of them's a Chief Justice. We elect that Chief Justice. Our Chief Justice now is Judge Deborah Lambert, and excellent judge. And all of us tell her what to do, and she does it. In her work, she does a lot of extra work as a Chief Justice and makes nothing, like $6 a day extra. Anyway, we do the administrative docket. The second docket of the day is in the afternoon, and we call that the rollover and the regular docket. The rollover docket comes from the month before. We get in a debate, somebody gets the majority, 4 people say, okay, this is what we want to do. The 3 that are in the minority, or 2 in the minority, or usually just me in the minority, writes a dissent. And we put it over for a month and put it on the holdover docket so I can write my dissent and they can read it and decide if I can flip them. And I have flipped them a couple of times with my dissent from going one way to going another. And that's our holdover docket. It's a holdover from the month before. Then we go to the regular docket. The regular docket is during the 3 months I'm down here in Bowling Green at my office here, we are working on cases and opinions, written opinions. And these opinions can be appeals from civil litigation, appeals from criminal, from the Court of Appeals, or direct appeals if they got more than 20 years. Back when we wrote the 1975 law, I was there in 73 when the American Judiciary Society came down and helped us write the new Constitution. And one of the things we thought, well, this 20-year sentence goes straight to Supreme Court. There weren't any 20-year sentences back then. They were only reserved for murders. But since 1975, the legislature has been tough on crime. And so what used to be a 5-year sentence now can be a 20-year sentence. What used to be, we have many more crimes on the books now. When I marry people, which is the most fun thing I do, is marry people. Marry my friends, especially my good friends, because I'm not on the list to marry you, so you got to call me and ask. Anyway, I got a book that's about that thick, and I marry them with this book. It's got every law in the state of Kentucky, civil and criminal, out of the legislature in 1948. Every law. Now, you've seen the shelves of books that have all the laws in them. There's a law for everything. I had one case where a woman was buying her grave on time with payments up at Cave Mill Cemetery in Louisville. And about once or twice a year, she'd go out and visit her grave and, just see how her grave was going to be when she died. She got out there one time and there was somebody buried in her grave. So she goes to the people at the cemetery and they said, oh, we made a mistake. Can we move you? She said, I'm not moving. That's my grave. I've been paying on it for 15 years. Well, this guy was buried in the grave. They had made a mistake and put him in there. And I didn't even know they did this, but this was a father and son grave. They have the father in the grave at the bottom, and they were going to bury the son on top of him in the same grave. I just didn't even know we did that. So anyway, I'm going, what do I do with this case? They brought it up to me to decide about whether this guy has to move out of her grave. There's a law for that. I couldn't believe it. I found this law and it said if you're buried in the wrong grave, and it told exactly what to do. I couldn't believe they passed laws on such minute subjects, but they apply. Anyway, when you appeal, you have these deadlines, and as from the Court of Appeals to the Supreme Court, Court of Appeals, we had 14 judges. There's 7 judges from each district, 1 judge from each district on the Supreme Court, 7 districts. And there's 2 judges on the Court of Appeals from every district, 7 districts, 14 judges. In 1975, we had 7 congressional districts. We made the 7 congressional districts the 7 districts that we elected our justices in. We never thought that we would lose population, and 5 years later, they took away one of our congressmen, and we had 6 congressional districts and 7 judicial districts, and that's the way it stands today. And we still voted on our justices in the 7 districts, and it never changed from those 7 congressional districts. Well, during the 50 years since then, people have moved toward the interstates. And the 1st district and the 7th, way over on the other side of I-75, shrunk in population. And the Golden Triangle, Lexington, Louisville, that area has grown tremendously. Bowling Green has grown tremendously. So our district had 100,000 more people than the 1st district. So I'd get elected with 100,000 more votes than the guy over there. So we did it by population, and we reapportioned probably 3 years ago to bring them back into population compliance. And my district used to have 14 counties, and now it has 17 counties. I used to have Owensboro, but Owensboro went to the 1st district to give them some population. And I added Spencer County and places that never been before. And in my last election, my opponent hired a big public relations firm, and they sent these postcards, lots of postcards, but they were sending them to the old 14 counties, not to the new 17 counties. I was getting all these calls from Owensboro saying, I can't vote for you, can I? You're not running up here. I said, no. He said, well, I got a postcard telling me to vote for your opponent. I said, good. Okay, got another question out here. Kim Yates is the only one with that.
Well, I'm not coming back up there, but what's your staff made of? Like,
Okay.
I've already been up there once, I'm sure you know.
All right, we get 3 staff members.
Yeah, law clerks and.
Yeah, well, we don't call, they called me a law clerk when I worked at the Court of Appeals in 1973. That was because at the end of a year, I left. We call our staff attorneys because they might be with us for 40 years. 30 would be the max, and you'd retire from the state. In fact, I had an excellent staff attorney that when I got on the court, and she got 32 years in, she had to retire, Leslie Berry over in Glasgow. Just a wonderful, wonderful woman. Anyway, we have 2 staff attorneys, and one, Relena Hunley's been with me about 15, 20 years. And the other one, John Brettenstein, has been with me about 5. And we have a secretary. And so it's a small group. The 2 staff attorneys do the preliminary draft opinions. I read the case and I outline what I think it's going to be, what it should do, what the ruling ought to be. They might come back, and my law, a lot of my law is out of date in my mind, because I'd practiced a case 35 years ago, and that's where my law stopped in that type of litigation. And sometimes they come back and say, the law changed. You're no longer right on this. And I say, okay. So they draft it, and then we edit back and forth. All 4 of us jump on the editing. And I do the draft with one attorney, and then when it gets pretty well done, we then pop it over to everybody. And then when we send it around to the other judges, we post it on, well, we have a thing called C-Track. C-Track, we post motions for discretionary review and our opinions on C-Track, and then the other justices vote. But we not only do that, we edit their opinions. So everybody's editing, so our final product will be the best product we can present to the public. And with 7 votes and 7 people with different legal backgrounds, we chop up and criticize, and we do that in conference, because the second day was the holdover docket and the regular docket. The third day is oral arguments. Now, oral arguments are decided by motions for discretionary review, usually, except for those automatic appeals where you have more than 20 years. And a motion for discretionary review, you file it and you say, I lost in the circuit court, I appealed to the Court of Appeals, I lost in the Court of Appeals, and now I want you all to take the case and tell them all they're wrong. And that's the motion for discretionary review. And we have a motion for discretionary due docket on Tuesdays. Tuesday afternoon, we have motions for discretionary review. And there's probably 60, 70 of them a month, people wanting us to take their case. We have 3 staff attorneys who are excellent, who read those, summarize them, and make recommendations to us with about a 3-page summary of the facts and law. And then most times we agree with them. We'll deny the motion or we'll grant the motion for discretionary review. Some of them we'll argue about it quite a bit, because some of us want to take it, and as a general rule, if we can get 2 or 3 of us to want to take it, the rest say, okay, we'll take it. And then we can grant them to be an oral argument or a non-oral argument. And the non-orals, some of our orals should have been non-orals. They're boring as they can be. And we look back and we went, staff attorney said not to take this case, and now we're hearing it. Anyway, on Wednesdays and Thursdays we have oral arguments, and we might have, last month we had 6, I think, or 7. And that means we go out at 10 a.m., the lawyers come up, we've read their briefs, they argue their case, we ask them questions, and the only thing I want is the truth from them. And one time a lawyer lied to me, and my blood pressure, my pulse went way up on my watch. I was going 140. I've never been there. This guy lied, just lied. Really upset me. I'm not going to let that happen again. But anyway, that's all you want's the truth. And then we go back and we argue or debate with each other what the case best resolution is. And you can't pigeonhole these people. I mean, I'll tell you what. There was back in '73, we had a new justice or new judge come on the Court of Appeals. His name was Ples Jones. Ples was from over around Somerset in a more rural area. Talked real country and had country justice. And the first thing he said was, anytime there's a reversal of the Commonwealth, of the prosecutor, mark me as dissenting. I'm always going to vote to convict and to hang them. And we went, wow. So anyway, he got a case. And in this case, the guy was pulled over for DUI and he blew a 43. Now they'd take you to the hospital. At 33, I think you go to the hospital if you blow that high. Well, he blew a 43 and he's in this police station and he's being questioned and without a Miranda, and he admits to burglarizing a house. Well, they appeal and say that he was way too intoxicated to have any capacity to make a confession. And he said, I don't know what to do with this one. I'm not going to reverse it, but what do I do? And he kept coming back, and they say, how are you doing on that case, Ples? He'd go, I can't figure out how to affirm it. And so after about 6 months, he came in and said, I got my opinion. And the opinion said, we affirm the court because a drunk man's words are a sober man's thoughts. If you think of that. Well, so I got off track there. That was just a memory of old Ples. We also I had real titans on that court, and because I had worked at the highway department where all I did was try condemnation trials. And during that part, I realized that I didn't understand law. I hadn't learned anything in law school, and I needed some help. And then I got this job at the Court of Appeals. So I go up there, and these 7 guys are arguing and debating the law, and that's where I learned my law, right there in that 1 year of listening to those people. And the number 1 strongest Supreme Court judge, appellate judge, that we know of in the history of Kentucky is John Palmore. John Palmore went to Western. He was from Henderson. And my daddy and him, my dad was the head of the debate team, and Palmore was on the debate team. And they had a big old car, a car that held 4 passengers in the front seat and 4 passengers in the back seat. Western owned this car, and this is like 1931. And the car would take them to the debates, and they went up to U of L, and they would debate, the Western team would debate the U of L law school team on should we have a trial by jury. Things like that still resonate today. So anyway, they also used the car for basketball. Coach Diddle would get in the car, my dad would get in the car, and 6 basketball players. That's all they would take to go play basketball. And so my dad said they went to Louisville one time in that car. They beat U of L. And then they went over to Lexington and they won. And the next game was at Center. And they said, the roads are flooded down there and you're not going to make it down to, where is that, Danville? You're not going to make it down there. And Diddle said, oh, we can make it. So they get to this place where they're on this gravel road coming down a hill, and there's a water coming down at the bottom, a ford. And he said, he goes down that hill as fast as he can, and he hits that water and goes across, comes up the hill, and bam, the oil is all gone from the car. They'd scratched the bottom of the oil pan. So Diddle got under the car and found the scratch, got out. My dad said they had 2 things they carried in the car. They carried a case of oil, because those cars burned oil, a lot of oil. He had to always keep putting oil in them. And they had a case of Wrigley's chewing gum, sent to him by the Wrigley Company. So he said, Diddle got the gum out, and everybody chewed as much gum as they could, a big old fat mouth. And Diddle went along and took all their gum, and he crawled under their car and pushed it up under that oil pan, and they filled it with oil, and it worked, and they drove on to Danville. So the next morning they go to the car dealership, and they said, well, it'll take 3 days to get an oil pan. Diddle said, well, let's just drive back to Bowling Green. They drove back, and they never fixed the oil pan ever. Just left it with the gum in it, and it worked for the rest of the life of that car. He had another one about that car where they were down in Mississippi going to a basketball game, and these rednecks started chasing the car, and lots of words going back and forth. So Diddle used to be a professional boxer, and he's a little guy, but he's a pretty big punch. And so anyway, he stopped the car, and he said, boys, just get out and stand behind me. And he got out there, and he said, all right, you boys want to fight? We're going to fight. I'm going to fight the biggest one of you right now. And then I'm going to fight the second one. And then I'm going to fight the third one. And these guys are going to make sure it's a fair fight. And first guy comes out, and Diddle knocks him out. Second guy comes out, Diddle knocks him out. And they got in their car and drove off, he said. So anyway, I don't have anything. That sure was good paralegal talk, wasn't it? Any more questions? All right, we're going to adjourn 5 minutes early. Thank you.